In the state of Florida, it's a challenge. It's complex to sue a healthcare provider, including a doctor, a hospital, nurses, or other ancillary employees in medical malpractice. It's required that you establish that there's been a deviation from the standard of care. And what that means in layman's terms is they failed to do it the way they should have done it, what the prevailing custom is in that community. And in addition, you have to establish that not only did they fail to do what they should have done, but that it caused harm to the patient. So there's a legal cause nexus that's required in a medical malpractice case. In a medical malpractice case, unlike any other type of litigation, you get in a car wreck in the morning, a lawyer can have a case filed for you by the end of the day. You can't do that in a medical malpractice case. The law requires pre-suit investigation. Pre-suit investigation is something you must give notice to the potential defendant, the person you're going to sue, and you have to give them 90 days of informal discovery. And it's an exchange of informal discovery. And most importantly, you have to have an expert or experts to verify your belief that there has been medical malpractice that caused harm to the individual. So it's a very high standard and very complex. And that's really why it's so important for people that have been harmed to go to someone who has the experience, the knowledge, and the team of nurses and experts in other areas to supplement the litigation team. It's very important in our firm. We have in-house nurses. We have people that have experience to evaluate the cases. And the evaluation of the case takes place before you even file the notice. It's critical that you have people that know how to handle medical malpractice cases, and everybody doesn't. So it's critical that an individual who believes that he or she or their family member, someone close to them, has been harmed, damaged by medical negligence at the hand of a healthcare provider. And again, it's the doctor, it's the nurse. It could be the policies of the hospital staff itself, non-physician personnel. I've seen the gamut of what occurs in medical negligence situations, that it caused harm. And I often use the scenario for illustration. If a car runs through a stop sign and doesn't hit anybody, it broke the law, but it didn't cause harm. The same is true in a medical malpractice situation. Just because you have the deviation is not enough. You have to have legal cause that it brought injury or damage to the individual. We've spent a lot of time, literally, collectively, cumulative. We have hundreds of years of handling medical malpractice cases in the state. And it's very important to know that there's a statute of limitations. So as soon as you believe that you have had some type of injury, it's important to give us a call. And our experience has a unique feature in it. We did both sides. We used to represent the healthcare providers for 30 years. And now we represent individuals who are harmed by the healthcare providers. That gives us an insight as to what they're going to do. We know their game plan, and it makes our case even stronger. And we've had great success based on that experience.